Okay, great. So I'm just going to introduce you. This is your third time here. We're so happy that you've come on. We were actually, if you didn't come, we were going to actually just talk about temperament. So just for a little background for all of you who have never seen Judge Baddeley present in the past, he has a BA in political science from the University of Michigan, a Juris Doctor from Michigan State, and Detroit College of Law, and he's a member of the Michigan State Bar Association since 1978. He is the current Chief Judge of the 58th District Court in Holland. He's an adjunct professor at Grand Rapids Community College. He's an instructor at Michigan Judicial Institute and past presenter for us and the Michigan District Court or District Judges Association events. We really look forward to your presentation today, especially now in this time of intense interest in our judicial process here in this country. So with that, feel free to start your whole presentation. Thanks.
All right, thank you. And I didn't have an opportunity to copy my notes for the presentation, so I'll probably be flipping back and forth between them as we go here. But good morning, and again, I apologize for the late start. It is once again a pleasure to be invited to return to the Hope Academy of Senior Professionals for my lecture on judicial temperament and philosophy and its impact on the U.S. Supreme Court. The inspiration for this presentation stems from a weekend my wife and I spent in Philadelphia last fall. While there, I visited the National Constitutional Center across from Independence Mall, and I picked up a book in the bookstore there by Jeffrey Rosen entitled The Supreme Court, The Personalities and Rivalries That Defined America. And in that book, Rosen looks at the critical role of judicial personality and temperament in the process of arriving at Supreme Court opinions. In other words, it's not just the law and court precedents that impact these decisions. Judicial temperament is used by Rosen to describe the personalities and attitudes of the justice toward the institution of the court. In his view, the justice who is willing to be collegial toward his fellow justices and willing to compromise in order to reach a desired result becomes the more effective justice. In my view, he gives less credit to the more ideologically pure justice, whose narcissism, he says, relegates him or her to a position of bystander in the process, registering his or her lonely dissent. Dissents, in my view, in many instances, become the most important part of a Supreme Court opinion. I prefer to look at dissents, in the words of Justice Ginsburg, that a dissent, quote, appeals to the intelligence of a future day, unquote. My purpose today is to pass along Mr. Rosen's scholarship and research and to add to that by providing short biographical sketches of justices not covered in that book itself. It is a very brief survey of the history of the modern Supreme Court, concentrating on judicial personalities that created the opinions and their dissents. Events of recent months have caused me to divert a little bit from the main thrust of Rosen's arguments to address the impact of recent vacancies in the Supreme Court and the specter of court packing. Additionally, if time permits, I'll take a brief look at how personality affects our Michigan State Supreme Court decision-making process. Now, I must admit that today's project takes me beyond my comfort zone as a district court judge. While earlier presentations at HASP dealt with topics that I face regularly as a judge, today's effort takes me to the realm of avocation rather than occupation. I've been an avid reader of history since my youth, but beyond my BA degree in political science and my Juris Doctor, I have no formal training as an historian, and my teaching experience is limited to the adjunct professorship at GRCC. Today's effort, therefore, comes from an amateur historian. It lacks extensive independent research. The facts I present are believed to be accurate. The opinions that I hold are at least sincere. I will attribute the research of others that I have relied on and if requested, and I can give you an email address, I will give you a bibliography of selected readings from which there is no dearth of publications to choose. The ones I include in my selected bibliography are simply my favorites. Now, I apologize for not supplementing this lecture with PowerPoint or other written materials, but the press of my day job prevented me from doing this. For my part, I imagine myself back in the cavernous lecture room at Angel Hall in Ann Arbor, where I was fortunate enough to be able to listen to sweeping lectures by masters at their craft who would saunter up to the podium without notes and leave the listener spellbound for an hour. If you're expecting that from me, you'll likely be disappointed, but I would encourage you to assume a position and a comfortable chair, and we'll see how we do. Finally, while the new normal dictates remote hearing, I am forced to be anchored, which is, I think, is a good Hope College metaphor, both physically and pedagogically, to a more lecture-based format rather than my preferred Socratic methodology, an audience-guided format. I will, however, try to respond to questions as they pop up on my screen and hopefully have time for questions and discussions at the end. Rosen's book starts with the earliest courts and justices. I have fast forwarded to the beginning of the 20th century as my jumping off point for the survey of the modern court. When looking at history, it's sometimes difficult to find a clear demarcation between history and current events. I was first elected to the bench 14 months after the 9/11 attacks. And as we senior professionals have learned, decades go by in the blink of an eye, and it is unfathomable to me that nearly 2 decades have elapsed since then. Other than this election season, which seems to have lasted for years with no promise of ending in 5 days, recent events become compacted, and we must await the judgment of history. For those of you wishing a general outline of the eras to be covered, it goes something like this. Number one, the early 20th century, focusing on Justices Oliver Wendell Holmes and John Marshall Harlan. Number two, the FDR years, Franklin Delano Roosevelt, focusing on that president's efforts to shape the court. 3, the Chief Justice Earl Warren years. 4, the last half of the 20th century in court leadership under Chief Justices Warren Burger and William Rehnquist. And 5, the current court under Chief Justice Roberts. It's probably best to begin with a look at the judicial opinion itself. Obviously, all judges issue opinions. At the trial court level, those opinions focus on the admissibility of evidence, procedural issues arising from the pleadings, and opinions on the ultimate resolution of the case based upon the determination of the facts of that case and an application of the existing law to those facts. They have the limited purpose of addressing the dispute between the litigants and occasionally providing guidance to attorneys handling those issues in future cases. Broader issues of public policy or the determination of the constitutionality of legislative actions rarely apply at the trial level. In a high volume court like mine, the availability of quick appellate review means that, in essence, the only bad decision a trial court judge makes are the ones he or she holds onto and delays in rendering. As I was humorously reminded by Chief Circuit Judge Ed Post the day I was sworn in, shortly after the ceremony, he put his big paw on my shoulder and said, "Don't worry, Brad, you'll do just fine. Just remember, there's nothing you can do that can't be promptly overturned." Actually, I found that comment comforting. I issue more written opinions than most trial judges because I like the opportunity to explain my decisions in a more organized fashion than giving a hasty oral opinion from the bench. I take pains to make sure my opinions are correct because I owe that to the litigants, and I hate the idea of being overturned by those uppity judges who review my opinions. Generally, the appellate review of trial court actions is limited to one, quote, appeal of right to the next highest court, with any review after that as a, quote, appeal by leave, where the next appeal takes place only if the court feels that case is worth looking at. The only case I've had overturned, my opinion was affirmed by the Ottawa County Circuit Court as an appeal of right, affirmed by the Michigan Court of Appeals as an appeal by leave, and overturned by the Michigan Supreme Court on an appeal by leave. At the U.S. Supreme Court level, with some rare exceptions, a party seeking review of a lower court action files a petition for a writ of certiorari. Annually, the court receives and rejects thousands of appeals from state and federal court decisions. Justice and former Michigan Governor Frank Murphy called it, quote, a matter of grace, unquote. The 5,000 or so petitions received annually are put in what is deemed a cert pool, where the justices' clerks review the assigned petition and prepare a memo, which is then reviewed by each justice's clerk and then the justice himself or herself. If the case has some merit, generally about 30% of those petitions, it's put on a discussion list for the conference with all of the justices. The discussion list is probably inaptly named because most of the cases aren't discussed at all because the petitions have already been thoroughly studied. Each justice votes on whether to grant certiorari on any particular case, and if 4 of them vote to grant, it's placed on the court's calendar for argument and decisions. The kinds of cases the justices can decide can be broken down into issues involving 1, the interpretation of federal statutes passed by the Congress; 2, the legal relationship between the branches of government, which we refer to as separation of powers; 3, the relationship between the federal government and the state and local government, which we speak of as federalism; and 4, the relationship between the government and the individual. I've used the 20th century as the jumping off point because there were few noteworthy cases that preceded that time, and they were for the most part bad decisions. The exception, of course, is Marbury versus Madison, where our original Chief Justice, Justice Marshall, ruled that the U.S. Supreme Court would be the arbiter of the constitutionality of any statute passed by Congress or a state legislature. Probably the most prominent decision in the early history of the court was the Dred Scott decision, which was one of the attributed to be one of the causes of the Civil War, where Chief Justice Taney denied the request of the former slave, Dred Scott, to be protected by the federal courts. In fact, the ruling went so far as to adopt the extreme position of Senator Calhoun that there was a constitutional duty to protect slavery. And this, obviously, shortly afterwards, the Civil War was fought. The Civil War produced what are deemed the 3 Civil War constitutional amendments, the 13th, the 14th, and the 15th, of which today the 14th is the more important of the 3. And another decision of particular note, which I'll get to in a moment, is the decision in Plessy versus Ferguson, as well as what are a group of cases which are referred to as the civil rights cases. Now, up to that point, the concept of originalism was, for the most part, unknown or at least unexpressed. The courts proceeded under a common law system, and by way of backtracking, common law refers to the English legal tradition where the law is established less through legislation and more by the decisions of the court that produce a body of law. And it gave rise to the concept of stare decisis, which states that in general, an issue that has been previously decided by the Supreme Court will not be revisited or overturned except in exceptional circumstances. Now, when we get to Plessy versus Ferguson, that was a case where a person, an African-American, attempted or was prosecuted for riding in the whites only section of a passenger train. It's a good jumping off point here. As it reaffirmed the Jim Crow laws that were enacted following the Civil War and well into the 20th century that legislatively affirmed the concept of racial segregation. The Plessy decision was one that produced the concept of separate but equal, where the majority of opinions said that the concept that the African-American was being discriminated against is only because he chose to view it as such, because in the words of the justices writing the majority opinion, the train cars were essentially equal, and they had seats and they were going to the same place, though certainly the accommodations were less luxurious in the non-white section. Plessy versus Ferguson then is significant for two reasons. Number one, for the introduction of the concept of legalized segregation on the theory of separate but equal, and equally important for the dissent that was filed by Justice Harlan. Now, Justice Harlan was an unlikely proponent for desegregation. He came from a Kentucky slaveholding family, though it was a family he fought in the Union Army in the Civil War. And his experience in Kentucky, a slaveholding state, did much to shape his views that separate but equal was inherently unequal. And the other justice who's of note in this late 19th century, early 20th century period of time was Justice Oliver Wendell Holmes, a name that's familiar probably to most of us. Now, Holmes wasn't on the court when the Plessy decision was entered, but over the years, he found himself joining Justice Harlan in those dissents, but for entirely different reasons. If Harlan was the passionate advocate on the court, Holmes was the dispassionate social Darwinist who saw the court as having little to do other than to leave the state legislatures alone in their efforts to enact social policy changes. The early 20th century was the progressive era, where the impetus for social change was coming not from Congress, but from state legislative efforts to enact meaningful child labor or wage and hour laws or food purity standards. Those legislative efforts were largely rebuffed by the Supreme Court, who looked at the unstated liberties found in the Due Process Clause of the 14th Amendment and found only one: freedom of contract. They found that free men, and I emphasize the word men, had the freedom to enter into contracts, and if a person chose to agree to work 65 hours a week, no legislative enactment could prevent that. Similarly, if you were driving your Pierce Arrow down the road and the axle broke, sending you into a tree, you couldn't sue Pierce Arrow because there was what was deemed no privity of contract. In other words, you hadn't bought the car directly from the Pierce Arrow manufacturer, but from a car dealership. Therefore, the idea of products liability, where you could sue the manufacturer of a defective product for negligence or for that product liability claim, could not or did not exist because there was no contract between you and the manufacturer. Judge then, who later became Justice Cardozo, in a famous New York appellate opinion, McPherson versus Buick, overdid the idea of privity of contract, which opened the way to product liability lawsuits, which continue to this day. Probably 15 to 20% of our channels on cable TV are devoted to infomercials or advertising, encouraging people to make product liability claims for various products that may have injured them. I don't see that I have any questions at this point, but I want to make sure I'm not missing any.
I don't see any questions in the chat for you right now.
Okay, all right. And my voice is failing me here for just a minute.
And since Judge Canal has invited comments and questions throughout the lecture, just make sure you unmute yourself if you have a question.
All right, continuing then. The era of the early 20th century was known as the pre-Lochner era. It refers to a case involving a bakery owned by Mr. Lochner in New York. The state of New York had passed a statute limiting the hours of employment for any particular employee. And again, the Lochner case, relying on this freedom of contract issue, ruled that because the employee involved could agree to work excessive hours, that the state court had no business interfering with that contractual relationship. And Lochner represents the departure point where the Supreme Court basically putting their finger to the wind and noting that social policy was requiring some legislative amendments, and that the theory behind freedom of contract was essentially flawed, because there is not freedom of contract when one of the two contracting parties holds a much superior bargaining position to the other person. But Justice Holmes is one of the more interesting characters, because he really didn't care about the social policy involved. He was a social Darwinist, and he simply felt that if the legislature passed it, that the Supreme Court interfere with that legislation. So his laissez-faire attitude was more based on the legislature had the power to do that, rather than someone like Harlan, who says the legislature not only has the power to do that, but it's the right thing to do. Holmes didn't really care whether it was the right thing to do or not. Holmes just said that the Supreme Court shouldn't be involved in resolving those issues based on the state's ability to legislate. Holmes is probably best well known for his views on freedom of speech. And it's interesting in that regard because he produces one of the few comments from an opinion that most all of us are familiar with, which states that there is limitations on the freedom of speech, giving the example that a person is not free to scream fire in a crowded movie theater. Interestingly enough, he was originally on the position that the states or the federal government had the right to legislate actions that would limit the right to freedom of speech. The quote that I just gave you from it was the case from Shank versus United States, involving a person passing out pamphlets urging in the pamphlet that the person vote socialist and that they seek to have the draft law overturned. This was a World War I case. Holmes had stated that freedom of speech can only be curtailed if there is a clear and present danger involved in that particular speech. And interestingly enough, as innocuous as that particular pamphlet seems to have been, at least as we look at it 100 years down the line, he voted in favor of the statute that criminalized that behavior, finding that there was a clear and present danger. But that decision, although providing noteworthy quotes, was widely criticized, and it would appear that Holmes took those criticisms into account, did some more research, so that without changing his position on the law as far as the clear and present danger standards, his opinions after that date served to limit the ability of legislatures to curtail that freedom of speech. Now, obviously, the 20s moved into the 30s and the Depression era, and Franklin Delano Roosevelt's election to the presidency in 1932, and the so-called 100 days where the Democratic Congress, at the behest of Roosevelt and by executive decrees, entered several orders or pieces of legislation establishing the so-called alphabet statutes, the NRA, the CCC, the WPA, and other New Deal legislations. And these legislative efforts were routinely being thrown out by the US Supreme Court, much to FDR's exasperation. So it became his point of contention that the Supreme Court basically was not representing the will of the people. The people, the voters had overwhelmingly elected him on a platform of radical change to bring the country out of depression. And the radical change was being thwarted by an entrenched conservative Supreme Court that was routinely overturning these pieces of legislation in that they exceeded presidential or congressional authority. This led to the so-called court packing proposal by FDR. He couldn't get rid of justices, but he thought that if he could get more of his appointments onto the bench, that he would appoint people who took a more favorable view of the New Deal legislation and would therefore survive constitutional challenge. This, at the time, was not a popular idea. I'm not sure that it would have made it through the Congress. There's nothing in the U.S. Constitution that sets the number of Supreme Court justices. The number of justices on the Supreme Court have expanded over time based primarily on the growth of the country and the needs to have more justices to handle the inflow of cases. Each justice is responsible for overseeing one of our circuit courts of appeal. And we have 10 regions of federal appellate courts. Michigan is in region 6. That includes Michigan, Ohio, Kentucky, and Tennessee, which is an interesting geographic breakdown. And we have one justice assigned to oversee that. And I want to say that that is Justice Sotomayor, who currently is the justice who oversees that particular circuit, because occasionally there is the need for emergency appeals that forego the more lengthy application for certiorari process. And if you're seeking an emergency appeal to the Supreme Court, normally you will go through that justice who is assigned to that particular region where the appeal is emanating from. I think we originally had 5 justices, and I'm not sure exactly when we got to 9, but it was sometime in the 19th century. So we've been with 9 justices for a lengthy period of time. And FDR's proposal was to increase the number of justices on an age basis. Another aspect of federal judgeship is that there is no age limit for a justice. An appointment to the federal bench, whether it's the Supreme Court, Federal Court of Appeals, or Federal District Court, is a lifetime appointment. That's to be distinguished. For example, several states have age limits on their judges. Michigan is one of the states. I think there's about, last time I looked, I think 33 states have some age limitations on judges' service, while 17 do not. The age ranges from, in most cases, 70 all the way up to 90 in Vermont, interestingly. So that I'm up for re-election next week for a 6-year term. I'm pleased that it's an uncontested election, but it will be my last term as a judge because it is a 6-year term. And by the time the next election rolls around, I will have already attained the age of 70. So I will not be able to run for election because of Michigan's constitutional prohibition on people over the age of 70 seeking to run for judge. The other aspect, obvious aspect of the difference between my position and a federal judgeship is that my position is an elected position, where a federal judgeship is an appointed decision. But getting back to FDR's court packing scheme, the idea would be that as each judge on the bench reach the age of 70, that another judge would be appointed, not to replace that judge, but to sit on the court so that there would be more judges available who presumably will not be advanced into their dotage, where presumably at 70 years old, that's what happens. And it's still the case today, according to our Constitution. But it was not a popular idea at the time, though it threw a shiver through the other members of the Supreme Court. And as that legislative proposal was gaining its momentum toward an ultimate ruling at the U.S. House of Representatives and the U.S. Senate, another case came up for review involving one of the Depression legislative enactments, one of the New Deal enactments, where a justice who had previously rejected all of the New Deal legislation joined the minority that would allow for the New Deal legislation, forming a majority, which averted the court packing process, also produced probably the only and certainly the worst pun attributed to the Supreme Court, that the switch in time saved 9, that this justice's change in his vote produced the necessary majority that would allow the additional pieces of legislation to work through. And obviously concurrent with that was the fact that these older justices were dropping off of the Supreme Court through retirement, so that FDR was in a position to appoint his own justices. Not surprisingly, given the length of time that FDR served as the president, he's in first place with the number of justices that he nominated to the Supreme Court and were approved to the Supreme Court. They were all interesting individuals. They had some characteristics in common. One of the interesting characteristics is that the aristocratic FDR, obviously he came from old New York aristocracy, if there is such a thing in the United States, and old New York money, that all of his appointments tended to be justices who came from working class backgrounds. His first appointment, Felix Frankfurter, his family moved from Austria, and Felix, through his own efforts, was able to work his way through school, law school, and became the justice on the scholar seat on the Supreme Court. Interestingly, all of the seats on the Supreme Court, or many of the seats on the Supreme Court, through unwritten rules, are given to some demographic segment. Brandeis, Frankfurter, Cardozo, not in that order, it was Brandeis, Cardozo, and Frankfurt sat on the scholar seat, the smart guy seat, but also the Jewish seat. Brandeis was the first Jewish Supreme Court justice. Obviously, later on, Thurgood Marshall was appointed as the first African-American justice and replaced by Justice Thomas. We will, going forward, now always have a seat, a gender assigned seat, though at this point there are sufficient female justices that won't be an issue, but there would never be a point in the future where there is not at least one woman on the Supreme Court, and there is not at least one minority person on the court. And one would anticipate that more minorities would also fill out those. And it's a political decision as much as anything else. Some of some of FDR's appointments were geographical in nature. Probably one of the most interesting appointments that he made, one of the first appointments he made, was Justice Hugo Black. Justice Black, like Justice Harlan, was a Southerner. In fact, he had served in the Senate as a senator from Alabama prior to his nomination to the Supreme Court. He was, again, a very humble background, born in a small town in Alabama, who worked his way to and into the legal profession. He was not Ivy League graduated. He was a politician. He was of a liberal bent, at least for a Southerner, and he was also a former member of the Ku Klux Klan. Now, that latter fact came to light shortly after his nomination to the Supreme Court. It's likely that he was not the first Supreme Court justice who was a member of the Klan. Hopefully he was the last. He had disavowed his Klan membership, allegedly, prior to assuming his position on the Supreme Court. But shortly after his appointment, he and his wife went on a cruise to Europe, which is when the issue hit the fan, and he had to scurry back and made a nationwide radio address explaining that he was not a member of the Klan any longer, and the nation seemed to accept his explanation because the issue itself died away. Other justices appointed by FDR, besides Frankfurter and Black, included Justice Robert Jackson, again, a man of humble means, who came from a family involved in local politics in New York State, but not New York City, Tammany Hall politics, North and West New York politics, who worked his way up politically, which brought him to the attention of FDR as a potential candidate for the Supreme Court. Served FDR as Solicitor General and Attorney General prior to that appointment. He was patiently or impatiently in some instances waiting for his appointment to the Supreme Court. And finally, Justice William O. Douglas was also an FDR appointment, and basically in that order, all prior to World War II. And he was the Westerner. Roosevelt was looking for someone from that geographic area. And again, Douglas was of humble background. He was brilliant. He was Ivy League educated. And the one thing he wanted more than anything else was to be President of the United States. And at least early in his career, he regretted the fact that he allowed himself to be appointed to the Supreme Court because he viewed it as a political backwater. He had anticipated the vice presidential nomination in 1940 and assumed it was a done deal in 1944, but instead Roosevelt went with the politician Truman, anticipating that he probably was not going to make it through his fourth and last term, and wanted a vice president who was then serving in the Congress, thinking that that would make a smoother transition to that new president. Now, the justices appointed by FDR included new Chief Justice Harlan Fisk Stone, less prominent than the four that I've mentioned, were described by one of the pundits as 9 scorpions in a bottle, that they fought a lot with each other. Sometimes it became personal. Justice Jackson would generally not be speaking to Justice Douglas. And Justice Jackson, incidentally, was the chief judicial representative of the United States to the Nuremberg trials following World War II, and probably is most famous for his excellent scholarship and advocacy in establishing the principles of international justice that were came out of the Nuremberg trials. But it was, while a contentious relationship, it was one that oversaw a more liberal approach to the U.S. Supreme Court than had been previously involved. And by way of distinguishing among them, we hear a lot of talk about originalism as a preferred method of constitutional interpretation. Justice Black, our Alabama justice, was the original originalist. And he was an originalist because he wasn't formally trained in law school or at an Ivy League law school, and didn't have much of a background of legal scholarship. So his approach was the simple approach, which was to simply look at the language of the U.S. Constitution and make determinations from there. Now, he was a smart guy, and like Lincoln, was self-educated to a large degree, but someone like Felix Frankfurter would look down his nose at a Justice Black opinion, thinking that it lacked the level of sophisticated scholarship that Justice Frankfurter was famous for. And as is the case with the Supreme Court, President Roosevelt came and went. Justice Truman came and went. But the appointments remained on the U.S. Supreme Court. And Justice Vinson was the Truman appointment to the Supreme Court as the Chief Justice of the Supreme Court. Interesting story with that is that back in the day, there was a much more social relationship among the branches of government. It was not uncommon for a justice of the Supreme Court to be invited to a reception or cocktail party by the president or someone in the Congress. And Justice Vinson, and amazingly, given our present ethical standards, I mean, they would talk shop in the course of these receptions. And President Truman was privately led to believe that if he took action against the steel industry, as he was contemplated, that his action would be supported by the Supreme Court. And to President Truman's great surprise, his buddy Vinson actually voted against him, and throughout Truman's efforts to control and regulate the steel industry. Justice Vinson was followed on the Supreme Court by Chief Justice Earl Warren. Now, Chief Justice Earl Warren was appointed by President Eisenhower, and Eisenhower later said, my nomination of Earl Warren as Chief Justice was the worst damn mistake I ever made. interesting comment from President Eisenhower, who also selected Richard Nixon to be his running mate and told the world that the U-2 flight over Russia was a weather gathering data aircraft that was blown off course. So although he made some pretty bad decisions, he considered the appointment of Earl Warren as his worst, or one of his worst, which is unfair. It's unfair to Eisenhower because he had no reason to believe that Earl Warren would be anything other than a conservative justice. Earl Warren was a attorney general and governor of California in World War II. He spearheaded the effort to remove American citizens of Japanese origin from the West Coast to internment centers, which produced one of the worst Supreme Court opinions, the Hiramatsu decision, that where the Supreme Court endorsed the forced relocation of these American citizens because of their Japanese ancestry. And Hiramatsu is particularly upsetting because the decision wasn't rendered until late 1944. And by then the war was practically won. There was no reason to continue the internment. And the reasons advanced by Roosevelt appointees, who we would think would be liberal in nature, people like Felix Frankfurter, really didn't satisfy any known constitutional principles. Frankfurter was an interesting case. He had also, in the earlier Jehovah's Witness cases, sided with the legislative enactment that required students to pledge allegiance to the flag. Jehovah's Witnesses refused to do that and were then prosecuted under the rules established by the local school board. Now, Felix Frankfurter's opinion in that case had an eye toward what was going on in Europe. This was not at the end of the war. This was at the beginning of the war in Europe, and saw the salute to the flag as something that would bring the country together, because he foresaw before most the threat posed by the Nazis in Europe. Like I said earlier, his family came from Vienna. So after Vienna was swallowed by Germany in the Anschluss of 1938, it became clear to him that the United States was going to be going to war. He was a close personal confidant of FDR. FDR used him a lot before he appointed him to the Supreme Court. Probably, in fact, that probably delayed his appointment to Supreme Court. And again, Frankfurter, who might be considered liberal or libertarian, sided with the idea that these children should be forced to participate in the Pledge of Allegiance that was required in most all of the schools. So we get to the Warren Court in the early 50s, and as you are likely aware, the Warren Court took the court in an unexpected, I guess at the time, direction. And that involved the relationship between states and the individuals. And on a case-by-case basis, the Warren Court advocated that the 14th Amendment and the due process rights of the 14th Amendment, number one, applied to the state and state courts action. That's why there was a 14th Amendment. It starts with no state shall. It was designed to have the rights contained in the Bill of Rights apply to state court actions. So it was a case, it was a matter of each right that was already recognized as being available in the federal court system being applied to the state courts. The right to an attorney, court-appointed attorney, Gideon versus Wainwright. The most famous decision from the era, of course, is the Arizona versus Miranda decision, which produced the Miranda rights. And but it was basically a process of the Supreme Court expanding the notion that individual liberties included these specific rights in the criminal justice realm, and that the state courts were as bound by the federal courts to recognize rights against incrimination, basic criminal procedural rights like the right to have an attorney present at various stages of the proceedings, the right to a trial by a jury, the right to have a fair trial, the right against prosecutorial comment on the right to remain silent. That is, it recognized that a person has the Fifth Amendment right at trial to remain silent, and the prosecution in a case cannot make a closing argument based on the defendant's failure to testify. And that's an instruction we give the juries today, that the defendant has an absolute right to not offer himself as a witness at trial, that that is not evidence of guilt. Prosecutor may not comment that it is evidence of guilt. Otherwise, in every case, prosecutor would say, look, he knows what happened. He could get up here and testify, and he refuses to do so. Therefore, he must be guilty. Now, there's a million reasons for a defendant not to testify, usually because they have some kind of a prior criminal record that's going to prejudice the jury against them. But Fifth Amendment says you have the right against self-incrimination. That applies in court situations. It applies in police interrogations situations, which is what Miranda was all about. Miranda says, and there's been a lot of refinements of it, but Miranda says that if you are in police custody and police question you, before they can question you, they have to advise you of your right to remain silent and your right to have an attorney present before any questioning takes place. And that remains the case. Coincidentally, with the establishment of individual rights in the Warrens Court vis-a-vis the criminal justice system, we also have the development of the right to privacy. Justice Douglas, in his opinion in Griswold versus Connecticut, identified the idea that there are individual rights contained in the Constitution that are not expressly stated in the Constitution. It's sort of the anti-originalist view. But just as the earlier Supreme Courts had identified a right to contract, where nowhere in the Constitution does it say that there is a right to contract, Douglas says that among the various portions of the Bill of Rights, the Sixth Amendment, the Ninth Amendment, that in using the astronomical term, in the penumbra, which is the area around the sun during an eclipse, on the edges of the expressed rights are implied rights because of the fact that there are these expressed rights. So the Griswold case involved a couple who was prosecuted in Connecticut for giving birth control information to married people. In the 50s, it would still be illegal to either practice birth control or to disseminate information about birth control practices. And Justice Douglas identified that there are certain rights that are so private and recognized as private rights that the government simply can't involve themselves in it. Now, interestingly, his original draft of that particular opinion, rather than relying on this penumbra concept, had talked about the institution of marriage as being one of those recognized privacy rights. And it would have been rather ironic that a justice who had a penchant for getting married and divorced 4 times and marrying new wives who were several decades younger than he would base this monumental opinion based on his reverence for the institution of marriage. But he instead arrived on the concept of the right to privacy. And most people today would say, yes, an individual has a certain expectation of privacy. Certainly in the Fourth Amendment, we have an expectation of privacy in our homes and for our persons to not be subjected to unreasonable search or seizure. So the right to privacy is recognized in the Fourth, and on these multiple amendments became recognized in the Griswold opinion. It's the sort of opinion that you look at today and say, well, yeah, people shouldn't be prosecuted for practicing birth control or for giving information about birth control, and would generally meet with public approval. Of course, once recognized, the right to privacy then becomes the linchpin of the Roe versus Wade decision, as well as the Lawrence decision outlawing sodomy laws. So you start with good law based on the facts of that particular case, which may be expanded beyond the realm and produces a high level of debate and disagreement and contention among the general public, where people are, for the most part, evenly split on the idea. And anytime there's a new justice added to the Supreme Court, the first comment will be that and it's either, if it's coming from the right, it's a hopeful comment. If it's from the left, it's a dread-filled comment that this will mean that Roe versus Wade will be overturned. And obviously we're going through that same thing right now. It's happened before. When you look at the Reagan appointments, and Reagan said, I'm not going to make the mistakes that Nixon made by appointing moderates like Blackmun and Powell to the Supreme Court. I'm going to appoint conservatives who reflect my point of view. You have a Supreme Court made up of Rehnquist, Souter, Alito, Scalia. I know I'm missing someone, but a solid conservative majority. And the view of the pundits was that this solid conservative majority was going to undo much of the work of the Supreme Court, but it didn't happen. The Supreme Court had an opportunity to do away with the Miranda ruling. And Scalia was somewhat apoplectic when the decision came down 7-2 in favor of continuing Miranda. The basis for the opinion is that, it's so entrenched into our legal system now, almost everybody can recite what the Miranda rights are. It's just a natural and part of our criminal justice system, has been for the last 70 years. My math is bad, 60 years. they elected not to overturn that. It's the idea. It's the idea that stare decisis that I mentioned earlier says, if we've already decided it, we need to have a good reason to decide it again. The same thing happened with Roe versus Wade. You have a very conservative court addressing the idea of the Roe versus Wade decision. So they have an opportunity to undo it in Planned Parenthood versus Casey. And the best or the worst, depending again on your point of view, that they could do was to eliminate the trimester concept of Roe versus Wade while retaining the viability concept of Roe versus Wade. So it remains to be seen what's going to happen with our new court, which obviously has a solid minority, or I'm sorry, a solid majority who would be identified, at least by the pundits, as conservative in nature. But it's a lifetime appointment. People who you think are going to act in a certain manner don't always do that. When Rehnquist and Scalia were first appointed, everyone assumed that Rehnquist would be a lonely Chief Justice because he would always be in the minority, being an ideologue and adhering to his firm opinions, while Scalia was likely to be the consensus maker on the court and would, because of his charm and wit, would be able to get minorities to turn minorities into majorities. Rehnquist, as the chief judge, was interested in having decisions work out. Scalia really had little interest in the ultimate decision. He needed to be true to his ideological background, and his charm was lost on most of the justices who would be insulted in their minority opinions. All right, now I've been ignoring a question I want to take a look at here. Can you speak to the supposed concept of originalist? It appears to me that originalists such as Scalia, Thomas, and Gorsuch say that they are originalist and motivated only by a pure judicial philosophy, but are most often as predictably conservative or supportive of Republican Party positions as non-originalist judges are predictably liberal and democratic, i.e., is originalism a legitimate judicial philosophy or simply a cover for politically motivated decisions? The answer is yes. Originalism is a viable ideological concept, no doubt about that. It basically says it's not, you need to look to the original founding documents and exactly what they say in English, or at least the English of the time, and thereby determine their meaning. Now, it's more flexible than you might think. A person like Scalia, who's an originalist, says that originalism supports the idea of Brown versus Board of Education, that schools cannot segregate against racial minorities. But originalist principles would not, in the Virginia military case, support the need to have military schools accept female as well as male applicants. So the scholars and the pundits can point out inconsistencies in originalism. But it would be unfair to Justice Scalia to say that he cynically only applied originalism when he needed to, because like I said, he wasn't that interested in the result. He was interested in his view. And when it appeared that it was, for the most part, a view done in dissent, it became more of a public thing with him than something that, in other words, he expressed his dissents in public. And I should probably wrap up. When we look at the present Supreme Court, our present Supreme Court justice hates the idea of 5-4 decisions, because 5-4 decisions resolve the case, but don't establish any reliable law, because you're always looking for that new person, that new swing voter. Justice Roberts clerked for Justice Rehnquist, who was really an excellent justice, and he did. They have the same idea or tradition that involves the need of the Supreme Court Chief Justice to be ideologically detached, that he's looking for resolution of the case without having an agenda. One of his complaints was that the swing vote became such a popular thing. Justice Sandra Day O'Connor, Justice Anthony Kennedy were the swing vote, the people who produced the 5-4 majority, switching back and forth. When someone asked Justice Roberts about, so how do you determine the swing vote? He said sarcastically, well, we share it. But that's the last thing he wants. He would like to see unanimous opinions, because unanimous opinions are better opinions. Brown versus Board of Education. Than the Alexander case that said all deliberate speed in desegregation espoused by Brown versus Board of Education means now, means right away. It doesn't mean waiting years, since the Southern districts had seized on the idea of deliberate. The New York Times, Washington Post, Pentagon's papers, opinions needed to be unanimous, expressing the right of the freedom of press. The Nixon tapes was an unanimous opinion. There are certain cases that need to be unanimous to reflect strongly the position of the Supreme Court that this is the law, this is the right policy, and this is the way to do it. And the penchant of recent Supreme Court opinions to go 5-4, where it became a sort of a celebrity contest to see who would be the swing vote, is improper. And that's, you can look at Justice Ginsburg and you can look at Justice Scalia, both fine justices, both brilliant scholars, but celebrities. And I think that's one of the other complaints here, is that Supreme Court justices should not be celebrities. They shouldn't make the talk show or news show rounds, and their opinions shouldn't look toward their celebrity status. And I don't blame, I'm not saying that either of them sought being a celebrity. It just sort of happened. You can get a Ruth Bader Ginsburg bobblehead. You can't get I don't think you can get a Breyer or Souter bobblehead. And I think it's important that the Supreme Court as an institution avoid that sort of publicity seeking. And again, I don't blame the justices for it. It's probably just a reflection of our society, where everybody has to have an opinion about everything. But that's probably, since I'm guessing we're running out of time here. I can go on as long as anybody wants me to talk. I'm a lawyer by trade, so I always talk until someone tells me to shut up.
Well, I'm certainly not doing that. I will say that since the class started a little bit late, there are people that have prior commitments. So if you're one of these people, you can certainly exit the class if needed. But as long as you're willing to stay on for a few minutes, we did have a question earlier before you came on, and I'm trying to look through the chat to see if there's anything else. I have a question from Jane Schuler, but let's do that. And then we have one from George Borcher, who I think is still on the call. Jane asked, why can judges have split decisions, but juries have to be unanimous?
Good question. Tradition. I had a unanimous jury verdict, which applies only in criminal cases. You don't need to have a unanimous jury verdict in civil cases. But in criminal cases, it has to be a unanimous opinion because that's one of the traditional fundamental underpinnings of our justice system. It was one of those things that the Warren Court addressed at the time of the where some states would allow a criminal conviction on a less than a unanimous verdict. They said, no, it's one of those traditional rights that apply federal courts and to the state courts. Now, the distinction with judges here is that you don't ever have more than one judge entering a decision in a trial. Trial is either takes, whether it's a criminal trial or a civil trial, it takes place either before a judge or a jury. And since there is only one judge at that trial, his decision is obviously, or her decision is obviously unanimous because he or she's the only one entering the decision. So it's only at the appellate level after trial, based on the record produced at trial, that multiple judges are involved in the process. And that process simply determines whether the trial was fairly held or whether some error was made at the trial level requiring a retrial or some other disposition of the case. So at the trial court level, it's unanimous if it's a jury, it's unanimous if it's a judge, because there's only one judge.
Thank you for that. There was a question that was posed earlier before you came on. Lynn, do you have that question written down? I don't think I'll do it justice. I think
No,
George
I have
Borcher
part of
still
it
on.
written. Can you hear me?
Yes.
Yes.
Okay, I have part of it written down. The problem is that after the first gentleman spoke to it, the second one said, no, that he had not wrong. So it had to do with if the Chief Justice is not with the majority, then the most senior justice assigns the opinion of the majority vote. Is that right?
That's right. Yep, that's at the in the process of arriving at the opinion, the judges all tip their hands, and if the Chief Justice is going to be in the majority, then he will assign that opinion to either himself or herself potentially, or one of the other justices in the majority. And if there's more than one person dissenting, then that dissent will be assigned. It gets complicated because frequently judges will also issue concurring opinions where they agree with part and disagree with the other part. So in the area of dissent, it's usually anybody can file a dissent, but where there's the majority opinion, that will be assigned by the Chief Justice if he's in the majority. That is correct. Now, there was a level of resentment because former Chief Justice Berger would sometimes assign it to someone and then take credit for it later on and essentially plagiarize that other justice's work. But I wouldn't want to cast aspersions on the late Justice Berger, but he was not one of the best Chief Justices we've had compared to Justice Rehnquist, who is equally or more conservative, but was a very effective and highly respected Chief Justice. And our present Chief Justice, having served as his clerk, would likely follow the lessons learned.
Great, thank you for that. George Borchter, he actually just looks like he stepped away. I was going to ask him to follow up, make sure that was answered his question, but there are two other questions I see in the chat. I'll go in order. First is, why is there such controversy over the Second Amendment? That's a big question. Why is there a reluctance specifically to limit guns in voting places and or Michigan legislature?
Well, that's a good question, but it's one, you know, it's one of those 50-50 split type questions where it seems like half the population is appalled by the idea that we can't impose effective gun controls, and half of the population is appalled by the idea that we would even think of applying gun controls. And I'm trying to think of the decision. It was one of the few decisions where Scalia was in the majority, the District of Columbia case, where the Supreme Court recognized that the Second Amendment involves an inherent right to possess a firearm. So it becomes difficult to pass legislation politically where there is a significant level of opposition, and it's difficult to enforce legislation that's passed because of the spin put on the Second Amendment. And the state of Michigan is an open carry state, which allows people to openly carry firearms. And there are certain exceptions, courthouses for one, thank goodness, churches for another. The ruling, as I understand it, on the Attorney General's attempt to expand the exemptions to Michigan's open carry law to voting places was rejected as being outside her authority. The legislature can do it, but the Attorney General can't. So now if your polling place is a church, you know, a ban on open carry could be enforced. If it's a township hall, it can't.
Thank you for that. I'm going to read this last question in case people start peeling off. This is a question that ends in right, so I think that she's looking for some either confirmation. Would the forceful use of dissenting opinions, like Sotomayor's opinion against Kavanaugh on Wisconsin's voting issue, is helpful to the court's overall credibility, correct? This doesn't hinder public respect for the court, but it is positive in purpose and effect, right?
I would agree with both of those statements. It's something I referred to earlier. I think at least the book that was the basis for this presentation gave, in my opinion, short shrift to dissenting opinions. Now, I personally enjoy Justice Scalia's dissenting opinions. They're brilliant, they're witty, but they can frequently contain ad hominem attacks upon the majority opinion that does little to enhance public respect for the court. It's the bickering among the justice. And Michigan had a horrible reputation for that about 20 years ago, where there were justices on the Michigan Supreme Court who just really hated each other, and it would show in their opinions. And I think that detracts from the respect that a court has. But the idea of a dissent itself is a good idea. I agree with Justice Ruth Bader Ginsburg, who calls the dissent as an appeal to the wisdom or intelligence of a future day. It was the dissent in Plessy versus Ferguson that led to Brown versus Board of Education as probably the most striking example. Dissents are a good thing. I generally, as a judge, I generally get more from a dissent than I do from a majority opinion, because it points out the weaknesses in the majority opinion. If everything's in the unanimous opinion, like I said earlier, sometimes it just needs to be as a public policy pronouncement. But if everybody votes with a majority, there's not much room for consideration of opposing arguments.
Great, thank you so much. We'll go ahead and start to wrap up the class. There is a great question. Oh, what is the title of the Rosenberg book? And I can just send that out in the chat to everyone.
Yeah.
Grab a pen if you're interested in seeing that.
You know, it's what I was talking about earlier. The last couple of decades just go flying by. So when I actually picked up the book, I thought, well, here's a good book on modern Supreme Court, but it's already 15 years old. Let me.
I can Google it as well. I just didn't hear.
No, I thought I had it with me. I came running in here and threw all my books down and thought that was in the group, but I don't see it right now.
You mentioned it at the beginning of your
Yeah,
presentation.
that's what I'm going to do. I'm going to pull up my original here. If I can get out of the full screen. There we go. No, not there.
Is this Justice Gerard Rosenberg?
No.
Okay. Mark Rosenberg?
I thought it was Rosen, not Rosenberg.
Yeah.
Oh, it's just Rosen. Okay.
Jeffrey Rosen. And the name of the book, it's Jeffrey Rosen, R-O-S-E-N. The name of the book is The Supreme Court, the Personalities and Rivalries That Defined America. And actually, the book was a companion to a PBS series by the same name, which I haven't seen, that aired probably contemporaneously with the book 15 years ago. It was when Justice Roberts was first taking the bench. So the last chapter of the book looks predictably at what they might expect to see, and fairly accurately as far as I can see. There's also a series of books by, I want to say Jeffrey Toobin, who unfortunately gained recent notoriety for a Zoom cast that he did that lost him his job. But before that, he had written a couple of excellent books. The Nine about Sandra Day O'Connor's court, The Oath regarding the Obama court. My personal favorite is a book, and I don't know that I have the author in front of me, called The Scorpions, which is a book about the FDR justices. Excellent history, I think. The Woodward book on the Brethren, the Burger Court, is another excellent book that I've read and referred to again for my presentation. And there's scads of books on Ruth Bader Ginsburg and Justice Scalia. Again, part of this celebrity aspect to them, but still good and interesting reading.
So I've included and this isn't a plug for the book, but there's an Amazon link to that book in the chat to everyone. And then also just Jeffrey Rosen, The Personalities and Rivalries That Define America. So that information's there.
Thank you.
We appreciate so much your time and in a wonderful presentation and just I guess stepping up in this strange time of presenting. So if everybody,
Yeah,
before you just thank Judge Knoll.
For eventually showing up. Thank you. And a judge's job, among the judge's jobs, is to educate the public. If there anything comes up that you have a question about, please feel free to email me and I'll do my best to answer your question, because that's part of what you taxpayers pay me to do.
Thank you.
We appreciate it so much. Thank
You're
you.
welcome.
And
We'll see you in a month.
yeah,
Okay, thank you.
absolutely. Thank you.
Bye-bye.
Thanks, Lynn.
You're welcome.
Appreciate it very much. I'll go ahead and close the class and everybody enjoy the day.
Thank you.
Bye-bye.
Thank you again.